All right. Good afternoon, everyone. We're a little behind schedule, and so we'll keep it moving right into this IP protection panel. My name is Pham, and I will be your host and moderator here. And this is a very esteemed panel of intellectual property and legal professionals that hopefully will give some insight into why intellectual property matters, what should we do about it in terms of founding, scaling, and potentially exiting your business. So one quick housekeeping matter, we will take questions in the comments panel on the side, and I'm going to do my best to keep an eye on that and make sure that we address everyone's questions. And at this time, I will allow our panel to introduce themselves, and I'm just going to do this in alphabetical order. So Candice, would you please introduce yourself to the crowd?
Hello, good afternoon, everyone. It is fantastic to see you. My name is Candice Simmons. I am the managing member of the Cook Law Group PLLC. I have been practicing in this area since 2003 and am based in New York, but work for organizations and companies both within the United States, in Europe, across the continents of Africa, in Israel, and in Asia. I am excited to join you all. I think intellectual property is one of the most critical components of creating a business, and I look forward to speaking and talking with this esteemed panel.
Good afternoon, everyone. Jaret Davis, hailing from Miami, Florida. I have the honor of being the co-managing shareholder for the Miami office of Greenberg Traurig. I'm also a corporate lawyer, so I'll be deferring to my brethren on the more deeper aspects of IP, but I'll be giving the corporate aspects to it. Most of my client base are actually technology companies representing both on the venture capital and private equity side, but also the technology companies themselves. Also have done a number of efforts to help ecosystems, obviously in Miami, but also Norway, Montreal, and other jurisdictions. And I also serve as general counsel and co-founder of a major technology conference that's based down here in Miami, but caters to all the Americas. So absolutely thrilled to be here and look forward to a robust discussion.
Thank you. Putting pins in the map all over the globe. Let's have Lestin, and then we'll go back to Joe.
Thanks, Lee. Hi, everyone. My name is Lesten Kenton. I'm based out of Washington, D.C. I am a partner at Stern, Kessler, Goldstein & Fox, which is a full-service intellectual property firm based out of Washington, D.C. I specifically specialize in patent law, where my practice primarily includes enforcing and defending patents at the Patent Trial and Appellate Board, District Court, and before the International Trade Commission, ITC. And I also use this knowledge from the litigation side to help develop and protect high value patent portfolios for individuals and entities alike. Also, I'm an adjunct professor at George Mason University Scalia Law School. And prior to jumping into law, I was a software developer for a number of years. So I have the benefit of seeing IP both from the engineering and development side and now from the legal side.
Fantastic. And Joe.
My name is Joe Drayton. Can you hear me, Lee?
Yes,
okay,
we can.
Excellent. So I'm a law firm partner at Cooley LLP. We've been a historic leader in partnering with emerging companies, and innovation has been at the forefront of our firm since our founding decades ago. We work with unicorns, Fortune 500, and I'm an intellectual property partner in our New York office.
Fantastic. And I neglected to let you all know who I am beyond my name and what I do. So again, my name is Pham. I have my own company, Teleosis, where I provide management consulting that focuses on intellectual property, cybersecurity, privacy, and the like. My previous life before consulting, I was at American Express in intellectual property strategy and as a lawyer. Focused on building the portfolio, monetizing and commercializing that portfolio, and doing strategic deals that gave the company a strategic advantage. Did a short stint as a chief of staff to the head of corporate development, so saw all the inner workings of the company from an M&A and venture capital perspective. And on top of my day jobs, today I am a scout and partner with a small venture capital firm, Concrete Rose, that supports Black founders. So we'll try to bring that commercial and business oriented mindset to this discussion. And as we planned to deliver this panel we did talk about not over lawyering the conversation. Oftentimes, because intellectual property is such a deep subject matter expert space and very nuanced, it's easy for a lot of these panel conversations to get into the weeds. We'll do some of that to the point it is enabling to managing and running and scaling your businesses, but we're going to keep it as high level as we possibly can. And so again, I'll remind you, we'll take comments, or rather questions in the comments panel, which should be on the right side of your screens. And we'll go through these 5 topics, and we've got about 30 minutes to go. So we'll kind of just do a chime-in conversation here with our 4 panelists. The 5 topics are as follows. First, why you should care about intellectual property in terms of running and owning your business. Second is the asset protectable, and we'll talk about why I use that word asset. Third, when we should take action. So why we should care, what can we do with it? When should we take action is the third topic. Fourth, we're going to talk about how we are managing our IP from an offensive or defensive position. And then fifth, and kind of bringing it full circle, what is the IP worth, right? And that kind of ties back into why we should care. And so let's go back up to the top, why we should care about our intellectual property. And so to the panelists, if I am a founder, seed stage, Series A, or I'm scaling my business, or if I'm, doing quite well and approaching an exit, why should I care about intellectual property? Why should I focus on that rather than focus on scaling, building partnerships, finding new markets? Why should I focus my attention on IP? And let's ease into the IP expert. So, Jaret, I'd like your take initially.
Sure, no problem. My pleasure. The obvious answer is it really drives valuation. For many tech companies, valuation tends to be a function of anticipated potential, right? Tech companies, for obvious reasons, aren't typically heavy intangible assets. And many, ranging all the way up to Amazon until the last several years, aren't even cash flow positive. But what they do have is innovation. That's what's being invested in. When you bring in anyone all the way from an angel investor all the way up to private equity, they're investing in the innovation, and that needs to be zealously protected, not simply in terms of ensuring against infringement by others, although that's obviously important, but simply ensuring the company owns title to the assets itself. I'm doing a deal right now where there's a $20 million capital infusion. I'm representing the VC, and it's a cosmetics company, manufacturer. And the sole driver, of course, is the IP. Who owns title to the patents? Who has control over the know-how? What are the manufacturing processes there? This particular company is a great example because it neither owns nor leases real estate at all. All the employees are in the cloud, essentially. So all manufacturing is outsourced. So the only investment is in the IP. There are no tangible assets. And so it's that IP that's incorporated into the manufacturing and the continued innovation that comes out of it. And there's a lot of traps for the unwary. To give another war story, I had an acquisition where I represent the PE fund. The valuation was in the hundreds of millions of dollars, and ultimately the due diligence, we learned there were significant issues with title to the IP, so we had to pull the plug, which was unfortunate because we loved the concept. And so this is why, any founders out there, it's very easy to somewhat dismiss IP and say, well, that's lawyer stuff, or that's just being overly protective, or when we get to a certain scale. And later on in this dialogue, we'll talk about timing. It's not a binary. I'll say this probably 3 times in this discussion. It's not all or nothing. There's a smart way to do it. You can take an a la carte menu approach, but there are traps for the unwary with founders not realizing that it can kill your capital raise, it can kill your exit. And not to be, gloomy about this, it's just there's certain ways to protect it, and you really should look into that.
Thank you. I want to get Lestin's take as well, because Lestin, you're a patent attorney, you're an IP attorney, but you also did the hard work as a developer, right? Building the critical components of a tech company yourself. So why should we care? Why does it matter?
Yeah, it matters. Just to piggyback off of what Jaret said, it's oftentimes maybe your most valuable asset, which we'll kind of get into, that you can use to raise money. You can use to protect people or protect your entity and block others from out of space. So, when I think of IP, oftentimes at the beginning stage, folks do not know what is their most valuable IP asset. Is it the trademark? Is it the actual patent? Are there trade secrets, copyrights, whatever it may be? And you should be thinking about that early on, because at the end of the day, whether you want to enforce your IP from someone potentially infringing or copying what you're doing, or you also want to make sure you are not running afoul of someone else's IP. And so, if you are developing an invention of some sort and someone else out there is playing in that same space, you should be aware of what others are doing, because you don't want to walk into a lawsuit by accident or just by ignorance, for lack of better words.
Thank you. Really quickly, I want to pivot to Candace's take. We're using the word asset here, right? And I think oftentimes, just in the journalism and public space, we think of IP as a strictly legal concern, but we're clearly focused on IP as an asset here. Candice, what are your thoughts on putting on your business hat when you're thinking about IP?
So I'm a lawyer, but I'm also an investor and I'm a business strategist. So in terms of the allocation of capital and looking at it as an asset, I co-invest with my business partner, Ikram Magdan Ishmael, who's the co-founder of Venmo. And one of the things we identify when we're looking at investments and what's attractive as an asset is actually, and it goes back to Jaret's point, what we're talking about in terms of valuation. So the first thing I look at when a company is being invested in isn't just the product itself. It's not product market fit. You're actually looking at the fundamental value of the founders. Like, that's first and foremost. And so taking asset in terms of asset class and the IP and putting that to the side for a moment, a strong founder is someone who's able to create a blueprint for the entity and the business they're creating. And so when we're looking at intellectual property and we're utilizing the term asset in association with it, we're also talking about the steps that you've implemented in the creation and the foundational methodology of your business. For instance, when we're talking about something like a trade secret, well, by the time you get to seed stage, if you haven't identified trade secrets, you've probably not implemented what's necessary to protect what you're creating in the first place. It's too late by then. And so we're not just talking about pulling the plug, we're talking about your inability to protect market share and your inability to keep someone who could potentially be a competitor from properly competing with you by virtue of the fact you didn't have appropriate NDAs, you didn't have appropriate tools in place and mechanisms to have a trade secret. Seed stage is actually too late to be thinking about this. So when we're talking about assets, we're not just talking about the fact that you can use intellectual property in many instances for collateral for a loan, depending on the type of IP we're discussing. We're talking beyond that. We're talking about what's your value in terms of creating your entity. How have you thought about this from a business perspective? And what are you seeking to do to identify beyond just the product? I always give the example, yes, we know that Starbucks is great for coffee, but what it's really great for is allowing you to see a Medusa and know that you can get coffee there before you go to any other place. It's the ability to do a tie-in. That's a value in creating a business. How are you identifying yourself in the market and thinking beyond just what you're creating in terms of source code, what you're creating in terms of any fundamental product or investment vehicle that you're creating. So when I think about it being an asset, it's a tangible, well, it's actually an intangible asset, but it's a valuable property that can essentially be a way to procure funding, but it's only as valuable as the protection that you've put around it. And that starts not by seed stage, quite frankly, it starts at the inception almost of ideation. And the second you bring on your first intern, your first work for hire, the first person you have touching your product is actually the vehicle for how you're going to be protecting that entity. And so I think that's honestly one of the most critical components, is not just how valuable is it and what you do with it, it's what you do to protect it at the inception of the creation of these companies, or what you hope to one day be a company.
Very good. Thank you. Just real quick, Jonah, I want to let you know that I see your question and we'll definitely get to that. We're going to move on to the next topic. So we just talked about why we should care about IP. And I think that was a very wonderful, holistic discussion answering the question. Now our question is the asset protectable? And I think what Candice just gave us in terms of how she thinks of it about IP as an asset was a good lead into this. And so, Joe, I want to start here with you. How do we approach the question of whether or not we have a protectable IP asset?
Well, I think you got to come to one of us, frankly, and have us do an evaluation of your business. And it should be a periodic evaluation. That's not a heavy lift. That's not a huge cost. What we can do is identify, your intellectual property, be it a trademark, be it a trade secret, be it a potential patent, or some other form of IP, and give you advice on how to protect it. I think why periodic assessment is so important is to the extent you can obtain a patent, and you can obtain a patent not strictly on business processes, but there's ways to protect novel business processes in the patent space, as well as just hardcore technology. There's ways to protect software potentially, and we can help you with that. But on the patent side, it's first to file. And so you need to really stake your mark on intellectual property early in the patent space. So that's why you should do that assessment early and often. And then I think Candice raised a really good point about employees. And I go ideas, employees, customers, and how are you protecting your intellectual property as it relates to all three of these stakeholders, in addition to investors. And you should seek advice immediately. And really, as soon as you have enough revenue or enough investment to start protecting your intellectual property, you should do so immediately for multiple reasons. One, you have barrier to entry. You use intellectual property to keep certain competitors off the marketplace because you're more attractive than they are because you have a first mover advantage on your intellectual property. The other thing is every idea, every startup is not going to be commercially viable. You're not going to make it. But what will and can make it is your intellectual property. And so that can become more valuable than you ever imagined. The other thing is to assess alternate uses of your intellectual property that you can't imagine, but folks like us can, and we can help you, turn one idea into three ideas. I'll stop there, Lee.
Yeah, that was a really great overview. It was very specific to the patent space, and me being a patent attorney and having a lot of focus there in my experience, I always default there. Lestin, really quick, can you just give us an overview in addition to the patents and some of the protections that we can potentially get on our code and software? What other types of intellectual property should we be focused on protecting?
Yeah, so in addition to patents, you have trademarks. So are you protecting the name, brand, scent, for example, in some instances of your invention? You have copyrights, which are just granted by right. And we've mentioned trade secrets, which is, I won't get into the weeds, but it's just another way to protect, for example, soft code and whatnot. But even within patents, it's important to know that there are different ways you can protect your invention. I think of, for example, one of the biggest litigations in recent history is Apple versus Samsung, and a huge portion of that was about the design of the iPhone and that patent. So there's you can get a patent with respect to the utility or the function of your invention, but you can also get a patent with respect to the design, look, and feel of your product if it's possible. And so those are kind of the landscape of IP. But I actually just want to echo or re-echo something that both Candice and Joseph touched on, which is with respect to IP. It's super important to be thinking about this before you actually publicly disclose this to anyone, because oftentimes if you've actually publicly disclosed it, it sets a clock for protection. And if you're not aware of that clock, you may essentially eliminate or seize your right to actually protect that. So just something to be aware of as well.
Thank you, Lestin. I want to address Jonah's question now because I think we've reached that when should I do something, when should I take action point. And the question is specific, I think, to patents, but there's universal applicability when we're talking about taking action on our intellectual property. And so to synthesize the question, it's, if you're developing a product, you've made that product first, then another party unrelated to you later patents that same technology, but their technology was developed subsequent to yours. Can the other person's now patent be enforced on your product? There are a lot of technical nuances in the answer to this question. And the question also adds, in this case, you never sought a patent. So it's not as if you were behind in terms of filing later priority, but you've just got no IP protection at all. What do we do in a situation where we thought of it first, but we see our idea now protected by someone else subsequently, and it could even threaten our business? And I'll leave this open to anyone on the panel who wants to chime in.
I'll start. Well, Candice, you want to start? I see.
No, I probably am the bearer of not great news. I would love to hear what you have to say first.
Okay, well, look, if I read the question right, and if I understood it, you have two patents involved. You have did I read it right, Lee? Because I had a big screen up. But at any rate,
one patent, the patent is on the subsequently developed technology, and the technologies are the same.
Okay, so there's a product that comes first, the patent comes second. And so I guess the answer is it depends. Mm-hmm. And so if your product was out in the marketplace, I'll say a year before filing, or in some instances, a year before invention that's associated with the patent, then your product may serve as prior art to the patent. And so if they assert it against you, you can use your product to invalidate their patent if your product actually is covered by the scope of their patent. Then there's a different scenario where maybe your product came out after the patent was filed, and the patent ultimately issues. In that circumstance, generally, without being specific on the facts, your product would still infringe that patent because that patent was filed first and came before your product. And so that's the thorny situation there. I'll tack on that you can have a patent and you can exclude people from practicing your patent, but to the extent that they make an improvement on your patent, they still have a valid patent. And if the industry evolves to cover the scope of the added innovation that a second person improved upon a pre-existing patent, then you still have two valid patents. And so if your product evolves into the scope of another patent, then you would infringe that patent, even though that patent includes steps that you may have a patent right to. So it's a little thorny, but I think it's one reason that we said early and often, get your patents and continue to evaluate your product and the development of those products so you can continually protect your intellectual property. I mean, one thing you can do is you can have a patent issue and you can continue to build upon it in the patent office over time. So there's techniques that you can do to make sure that your intellectual property is as broad as possible. Candice, I'll let you jump in.
So I'm nodding. I'm in full agreement. So I don't want to repeat anything. The only the only thing I would add is there were two things that came out in that question. The first, that's also the reason that you want to speak with someone on this panel or a counsel, because there are other things that you can do to deviate and distinguish your product from their product. And so beyond just the patentability, there are different types of intellectual property protections that you could associate with your product to make it distinguishable so that on the market, even if you end up in litigation with regards to who has the right to actually be on the market, you can trademark a chime. I don't know how many, and I'm probably showing my age here, but if you recall, NBC, you used to hear da-na-na, that's protected. Those types of things and associating those types of sounds, or in terms of fashion, colors on your specific colors on your shoes, all of those things, the scope, the range of color, all of those things can be included in packaging and how you are designing your holistic product, such that two things, apple to apple, being almost the same, taking out the specifics of that fact pattern, still can hold market share based on the fact that you're who we want to go to because we want the one that has the chime, or you're who we want to go to, it's the one with the blue packaging, not the red. And the one other thing that came up, and I don't see the question, but I think Lee said it, is the idea part. I always get, and I think it's just really important that everyone listening appreciate the fact that idea is very different than execution. Having the idea first is not the same as executing upon that idea and how that idea is executed. So it's really important when you're thinking of, as a founder and as a creator, it was my idea. I had that idea first. Fantastic. Joseph mentioned patent is first to file. Well, it's also how you deviate yourself on the marketplace in terms of what does the consumer know? When they're going into the store, who are they actually asking for, regardless of who had the idea? What are they saying they want? Because the USPTO actually looks at that when they look at consumer confusion. Did they think they were getting the other guy or the other gal or the other human? If that's who they were thinking, and you actually are creating, not you, the person who's posing the question, but you as founders collectively, you've created an instance where the consumer is confused because of something you're doing, that can harm you. And that's incredibly frustrating when you know you've been in the lab working on this for such a long period of time, and really you just didn't come to market first or protect yourself in such a way that it appears that you were first. Ideas are not enough.
Ideas are not enough. I like that one. Jaret, really quick, I'd like your corporate perspectives, because there are a lot of nuanced rules about when you should do what and why it matters under the law and under USPTO procedure, USPTO being the United States Patent and Trademark Office, right? That's the agency responsible for managing intellectual property from a legal perspective. And so all the legalities. But Jaret, when we're talking about managing our business, and again, it's the competition between I have to do these things as a founder, I need to scale my business and think about this other stuff. How do I insert the timing with respect to protecting my IP into that thought process such that I don't drop any balls?
Yeah, and I think this is where recidivist entrepreneurs sort of always have an advantage because they've been through this game. A lot of it's strategy. A lot of it's sitting down with your budget and figuring out what you have the money to do and the timetable you have to do it. It's really a cost-benefit analysis, because let's take the extreme example. At the extreme, assuming you have an innovation that is patentable, you patent it in every single country of the world. That will also cost you hundreds of thousands of dollars at the very minimum. Not everyone does that. What you can do, though, is, so first off, let's lock down title. Candice nailed it. Everyone knows what an NDA is. Everyone talks about NDA. So the most basic is protect confidentiality. That's what an NDA does. But there's also what we call, and we all took a vow in blood, not to get too technical, but I don't think this breaks the rule, invention assignment agreements, which is when you have employees that do anything in any way, shape, or form touch the innovation, you get an invention assignment agreement, which basically confirms that any work they have, any claim to it that they have as an inventor or partial inventor is assigned over to the company. So that's very clear. And the reason why these steps have to come first is this is exactly what your first round of investors, if they are remotely, maybe friends and family won't, but if they're remotely sophisticated, the first thing they're going to ask is, get us comfortable that you actually own the IP. We got comfortable that your innovation has legs, that it's going to really be disruptive on the market. Now we need to make sure you own it, and that the super brilliant inventor that happens to be an employee or a founder even doesn't really own it individually. So that's step one. Step two is, let's suppose it is patentable. One thing we haven't talked about, and again, we don't want to go too far in the weeds, is there's something called provisional patents. So you have that 1 year rule that everyone mentioned. One way people try and short circuit that is to do a provisional patent, which is basically sort of a truncated version. And then you could go back in and do the more fulsome patent after the fact. And so there's all these techniques that are out there. And obviously the ultimate answer is talk to a lawyer, because we can all walk you through what that is. But what I want you to take away, and I mentioned this with respect to the answer to the last question, it is not a binary. It is. I've seen too many founders sit there and say, we simply don't have that kind of money, so we just won't do anything. And that is, if there's one thing you take away from this panel, never conclude that. There is always something. You're talking about a fairly broad menu, a toolkit that has a lot of tools. Use some of them. And through research and talking to lawyers, you as an executive can sit there and come up with a strategy which will allow you to get the maximum amount of protection. What you're trying to pass is the test of an investor. When the investor sits down and says, why should I give you $10 million or maybe earlier stage, so $2 million just to float you. And you have to say with a straight face that the IP that is the core of the entire business model is safe, relatively safe from a reasonableness point of view. Where yes, somebody in Singapore may be infringing. We'll deal with that after the fact. But I would hope that we have enough protection to say your own employees can't claim that they have a right to the IP, right? I would hope that we have some way, if it's a truly innovative technology and we truly want patent protection, that you've at least started the train going in terms of doing a provisional patent. All of these different techniques can come together and help you to protect things. And if nothing else, a smart tactic I've always seen is, as part of your use of proceeds when you're doing your first raise, part of it is IP protection. I see that in some very smart companies. They'll say, okay, we're doing our first quasi-real raise. Let's say it's about $2 million. We've earmarked 200 grand, 300 grand for IP protection. And I know of very few investors that'll say, depending on the business model, that, well, why would you do that? That seems like a silly use of funds. No, they're going to say, absolutely, you will do that. And the trickiest part is just convincing them you have a chicken and egg issue. Why should I give you the money when you don't have all the robust protections in place first? But you can get around that.
Very fulsome answer. And I think you got to Jonah's question. And I think Jonah sounds like he's cooking up something amazing because he's asking great questions here. His question is basically, if you're resource constrained, you have $0 in your bank account, what do you do? And the answer is you can always start to make a move, right? And I think a question with to a credible attorney, IP attorney, someone who knows the nuances of the space, will leave you better off than had you not asked that question, even if you're completely resource constrained. So go to a lawyer. And we're not just saying that because we're trying to drive business or anything like that. These problems almost always arise because there was not counsel in the first place, right? There was not guidance. One thing, and I just want to interject one thought here. I talked about journalism, business journalism around IP. I would not advise anyone to read whatever business publication it is and apply, one vignette, one story from one industry and one dispute to your particular situation. Moderna and its patents on vaccines is not the same as Apple versus Samsung, is not the same as self-driving cars with Waymo, is not the same as the color of the bottom of the Louboutins. It's all different. And it might not and probably doesn't apply to your circumstance, right? On top of that, most business journalists aren't IP lawyers. And so don't take synthesized legal advice from the newspaper, the website, the blog. Go find a professional. That said, I want to move on quickly to our next topic. We're a little over. I'm told that we have a 5-minute cushion, so I'm going to lean on that cushion right now. When we're thinking about, so the fourth topic we have here, when we're thinking about managing our intellectual property. So we've got the timing down. We secured whatever protection we need, patent, trademark, whatever, copyright. Now, how do we manage it? And does it just sit there? Does it remain registered and we don't have to do anything? Or should we be thinking offensively and defensively about it? And if that's the answer, then what? Is it binary? Is it offensive and defensive? Lestin, I'd like to get your thoughts.
Yeah. So to start, it's not binary at all. Oftentimes when I counsel clients, small businesses, solo vendors, big businesses, I also like to get a sense of what is their ultimate goal with respect to their IP. Do they want to just leverage it, sell it eventually? Do they want to use it to protect people, protect themselves, and exclude others from practicing what they're essentially inventing? But with respect to the offensive side of things, there's a whole business out there of folks that collect IP with the sole intent of enforcing it against anyone that infringes that IP. And so if that's your goal, there is a market for that. But there is also a thinking as well with respect to defensive aspect, is to acquire enough IP to protect your business. And so it ultimately boils down to, are there competitors out there that are cutting into your market share and affecting your ultimate valuation and your profits and bottom line? And if there are folks out there that are doing that and are indeed infringing your IP, then you're probably going to make the decision that maybe it's better off to approach those individuals and perhaps seek licensing of your IP, or go the full gambit and enforce that patent against them. And so, kind of get back to the beginning, it's not binary. It's really on a case-by-case basis, and kind of really is driven by your business goals, business needs, and what competitors are also doing in the space that may affect your ultimate decision.
Thank you. When we were prepping for this conversation, we also talked about it, not only offensive and defensive, but also carrot and stick, right? How do I use or leverage my intellectual property as motivators for different behaviors, whether that's with my competitors, partners, employers, investors, et cetera? Joe, what are your thoughts on how to position your intellectual property with that carrot stick framework, how to motivate those in your business's ecosystem to do what is in the best interest of your competitiveness?
Well, I mean, you got to determine whether you want to, I guess, license your IP or not as a strategy, and whether you're willing to license your IP. I mean, the carrot to me, I mean, the stick is using your intellectual property to create obstacles to competitors' growth, especially when they're looking for funding. So that's a way you could use it potentially as a stick. On the carrot side, I guess to the extent licensing is a way you could use it on the carrot side. I defer to other speakers on the carrot stick concept. And Lee, if we said something in prep, bring it up and we can elaborate on it.
Well, I think that was helpful. We've got 5 minutes left. And so I want to take the last 5 minutes and try to address any lingering questions, but also get to our last topic. And this last topic can be an entire law school course. All right. So we're going to give the header summary. The question is, what is our intellectual property worth? Jaret has the biggest smile, so it's yours.
5 minutes for that, so I'll be super fast. And we have come full circle because it once again links to valuation. I mean, a lot of times we talk about this, we talk about sort of three approaches, income, market, and cost. Cost means just book value, and IP is notorious under GAAP, generally accepted accounting principles, for being booked very low. So don't ever go with that. But beyond that, it depends on what life cycle your business is at. So let's say you're a mature business and you're actually generating meaningful cash flow, meaningful revenues, and more importantly, earnings off of that, then it's pretty easy. You run it through a discounted cash flow analysis, a DCF, and you could figure out discount, and you could figure out what the value is. Most of the time, most of you on here, because I think this is oriented more to the startup community, won't have that luxury. So then you get into trying to figure out based on comparable technologies out there, et cetera. And that's where you get more of an art form than a science as to how you do that. And at the end of the day, it goes by, once again, anticipating what it's going to produce. And it's sometimes importantly, how much you're going to be able to block another party's ability to exploit similar innovation. I mean, there's both sort of that defensive and offensive aspect to it. And then and this is all hard IP I'm talking about more so. I mean, we're talking soft IP, brands, trademarks, etc. Similar rubric, but it's going to be slightly different there. And the other thing I wanted to point out before I hand it off to the other speakers, IP is similar to real estate in which it's a bundle of rights. You can chop it up. So with real estate, I can own real estate, I can lease real estate, etc. Same thing with IP. You can license it. You can do all sorts of stuff. We're seeing this, there's a whole nother conversation in the NFT space. You've got image rights over here. You've got your copyright over here to it. Maybe it's a photograph, etc. And there's different monetization strategies on that. And so, again, this could go on forever, but just the gist I want you to take away, it's a basket of rights. And if you get very creative, you can find a way to monetize that IP in so many different ways.
Candace, can you give us one last snippet of your thoughts and just how do we think about valuation, when we're talking about a startup's IP? What is our IP worth? How do we think about that?
I think the first thing we know is that for founders, we appreciate that you are building the track while the train is coming. So you are bound to there are tons of balls that are in the air. There are tons of things that are happening. Everyone appreciates that this is not the easy route. This is a hard route in just building a business. when we're talking about, point blank, what's the value of the intellectual property? There are two things, just to go back, offense or defense. It depends on what type of intellectual property you're seeking to protect. If you've got something that has a very strong brand identity, the USPTO, and this is, I will candidly say, in my opinion, is one of the flaws of the way the system works. You do have a snooze, you lose opportunity there. If you are not zealously protecting what you are asserting is yours, you do run the risk of someone constantly infringing, and having IP and not defending it is almost the equivalent of not having it at all. You never want to be before investors, and they have a recollection of what it is you've created, and what they're recalling is not yours. And the reason someone else has been able to usurp into your vertical is, quite frankly, because you weren't keeping your eye on the ball in terms of how you were playing defense. So it's offense in the sense of creating a framework and a foundation for protection, but it's also defense. And once you've allocated that capital into protecting your intellectual property, it's critically important not to let someone come in and essentially, because you're not distracted, you're just working on valuable other things, you still don't want them to come in. So that's when your cease and desist are important. That's when really asserting what your rights are. And there's no such thing as someone who's too big to be fought. So just because you're a smaller player and someone has more financial resources, the federal rules don't change because you have more money to fight them. It just, the negotiation changes, right? So offense, defense, it's both. Value of the property, nothing if you don't seek to protect it. So in terms of how you're going about valuing the asset, it really is, what component of intellectual property are we talking about? And so we've all said that. There's one more thing. If you're talking about code, and we've discussed sort of things that can be patented, we could be talking about branding and trademarks. If you're talking about code, then you want to be really careful about what you're doing with open source code. Code that you're creating would then fall under copyright, right? Based on, depending, I mean, there's gray areas there, but generally speaking, when you talk about open source and now you're utilizing, you're all building on top of each other, the rules change. And fundamentally, that can go into what the value of this final product you're creating is, if I can extract out half of what you've made and turn it into something else. So it's, again, it goes back to the fundamental. How do we parse through it? Talk to someone else. You're not expected to know all of this. Really what these panels are intended to do are to trigger thoughts in your mind so that as you're building and as you're creating, you can say, well, I kind of remember someone talking about that. Maybe that's something I should look into and address it later. So yeah, I think the value is how much energy and protection you put around it. You can have it go up, the valuation can increase based on your protection, or it can decrease based on essentially letting it fall by the wayside and letting someone else come in and usurp the value for themselves.
Thank you. We actually have like 3 or 4 more minutes. And so I'm going to use this little bit of additional time that we have. I'm just going to voice over one of the questions, but then what tips can we give to folks after I voice over the question really quick? What tips can we give to folks on, all right, I got it. I'm supposed to go talk to a lawyer. This is some sophisticated stuff. I don't even know where to begin. So that's what I want you guys all to quickly address. But I want to voice over this question from Alfonso, and it's essentially says that the Supreme Court, SCOTUS, the Supreme Court of the United States, has rendered some opinions in several years that have eroded IP protection and what can companies do. To the back part of that, what can companies do? I think that we gave you the answer here, right? Because again, don't try to interpret Supreme Court decisions on your own unless you yourself are an attorney. That when you're dealing with your business, right? That said, it may seem like the Supreme Court has done a lot of erosion to patent rights, or IP rights in general. Intellectual property filing and protection is probably at its highest level ever. And so while these cases might get a lot of attention in the press and might be characterized as eroding IP protection, it's simply not the case that IP is any less valuable or any less important, especially when you're a startup. So great question, Alfonso, though, and thank you for bringing it our way. And so to the last part, really quickly, maybe 30-second responses, and I'll leave up to anyone who wants to take it. What should I gather up when I go to talk to a lawyer, or how do I even find a lawyer?
So I'll jump in for 2 seconds. I'm a big fan of knowledge is power. And one thing I've always marveled at in the startup community is how much information's out there. You got to take it with a grain of salt because some of it's wrong. But there are resources out there where, as an executive, you can educate yourself up to a point, but at least get the foundational education so that you could then sit there and come up with an initial strategy, which you could then run by the lawyer. I'm a big fan of lawyers and clients tag teaming that process. So I think the short answer is right now I probably see it's overwhelming because this is all new to you. So do a little bit of research. There's not much out there because there's a lot of material that you can read. Educate yourself a little bit, and then you'll be able to see. And you'll also, there's trends. You could see, I mean, Cooley's a phenomenal firm. I think Greenberg Trorig's a phenomenal firm. All of us represent phenomenal shops out there. And you'll see as you do your research, these names keep coming up. So you're going to learn very quickly who are law firms that know what they're doing in the IP space, et cetera, and then you can sort of source out that. These panels can also be invaluable for that kind of knowledge. Keep watching these panels and learning.
Yeah, Lee, I would just say, you're going to find companies, lawyers throughout your travels, at the various conferences you go to, TED Talks or meetups or whatever. You ask those lawyers to put you in touch with the IP lawyers, and we'll give you a little bit of time to give you the lay of the land. I do want to talk to the innovators and just tell you that there's a lot of IP out there live, but not really in use, maybe past its prime. But you may be thinking of it in a different way, and your innovation may be able to take advantage of existing intellectual property that you may be able to get on the cheap. So don't always think it has to be brand new. And I just wanted to throw it out there as a last comment.
I think that's a great place to leave it. We're right at 2:55 Eastern. This has been a wonderful panel. I've enjoyed speaking with all of you, and I hope that the crowd here has enjoyed as well and is enabled to go and grow, scale their businesses, and find greater success. And so jot down the names on the screen, find them on LinkedIn, find them in the find their bios online, reach out. And thank you everyone for your time. It's been such a pleasure and honor being with you today.
It's been a pleasure. Thank you.
Thank you for having us.
Thanks for having us.